Hello, everyone. My name is Chilotam Orama, and today I'm here with.
Ethan Sovereign.
Duke.
So, we'll be talking about contracts today, and more specifically, we'll try to answer the question, when is a contract made? So, as we all know, humans were built to be social beings, and we are sustained by social interactions. From going on social media, especially in this virtual world, to attending in person events, our moments are characterized by contributions from other people. We rely on the experience of people across different fields of this life to live holistically. Something else we know about humans from the study of, economics and from class and everything is that humans are rational beings. So we usually seek our best interest in every situation or circumstance, and that goes without saying that in our affairs with other people, our own personal interest comes first. So how then can I be comfortable to depend on someone or to even make a commitment to someone when I know that they're not looking out for my best interest? They're simply looking out for their own best interest. And that's where contracts come in. So what is a contract? A contract is simply an agreement that is enforceable by law. It's usually a written document containing the terms and agreements of a particular venture by two parties, which is signed by the parties involved. And the reason for contracts is because a lot of the exchanges of goods and services which happen during interactions do not happen immediately. Some of them might be promises that await payment or payments made already for something to be delivered. And contracts are elements that ensure that the behavior of the party we do business with is predictable. So when someone makes a payment, we are sure says they will make a payment, and we enter a contract with them on that, we are sure that they will do that. And at the end of the day, everyone is better off, which is the particular reason why people go into contracts in the first place. Imagine this example. Someone promises you that they're going to meet up with you next week, but he doesn't show up. That's a promise. But are all promises contracts? Or imagine the second example where someone promises you that it's going to rain, or that it wouldn't rain rather, but it ends up raining. What would you do? Could you go to the court to enforce the fact that they made a promise to you, but it didn't come to pass? So there are different elements of an agreement that makes it a valid contract, and these elements are the things that we'll be looking at.
So contracts typically consist of three parts. The first part being offer. Offer is made when the one party makes an offer to another party, and for a contract to be enforceable, the offer should specify the goods or services being offered. When a contract does not specifically identify the services or goods being offered, the contract could be void if either party chooses to dispute the contract at a later date. And the second part being consideration. So consideration is a legal way of saying something of value for a contract to be enforceable. Each party has to bring something of value to the table. In most commercial transactions, the consideration is the service and the product on one side and the cash on the other side. The last part being acceptance. When an offer is made by one party, the offer must be accepted by the other party for the contract to be valid. While the parties may honor a verbal acceptance and the court may enforce a contract in which the offer has been accepted in a reasonable manner under the Uniform Commercial Code, it is usually best for both parties to sign the contract, signifying the acceptance of the terms of the contract. By summing up all the things I've said before, an offer contains a promise. For example, one party will make X amount of money and they request for something in return, other parties belonging. The terms of this offer are then reviewed by the other party involved. When the other party considers the offer, they either accept it or reject it. In the case where the offer is accepted and signed by the other party, that's when the contract is made. And the importance of having a contract. Contracts provide a written document that outlines the full understanding of the business relationship and the scope of the work, so that no one could claim any misunderstanding later down the road. They specify exactly what rights are being purchased and what rights are you retaining. And they are binding and legally enforceable, and they protect both you and your clients. And they stipulate how and when you get paid, what needs to be triggered that payment, and what resources you have if the client stiffs you. And lastly, they minimize risks. Thank you.
All right. And now we'll go over some of the problems with entering into contracts. The main problem of entering into a contract lies within the court's ability to enforce it. There are many reasons a court may not be able to enforce a contract, such as examples listed here. The problem that arises with a lot of contracts is that if the court can't enforce it, the contract is useless and has no value. Some of these examples would include incapacity, which is an inability to agree to the contract if the contract were made with someone who was too young to agree to a contract. Duress, if the contract was made under threat of violence, a court would not be able to enforce that contract. Or if the contract had the problem of necessity, if a contract was made without one of the parties having a choice in the matter, then a court would not be able to enforce that contract. The same holds true for the problems of impossibility, derogation of public policy, fraud, information problems, unconscionability, doctrine of consideration. All of these have the common theme of being unenforceable by a court because there is some problem with the contract that disallows the court from enforcing the contract, making it useless to the parties involved. As a conclusion, contracts are very useful in business. They are able to make companies agree to certain stipulations, agreements, and limitations without having to worry about the enforcement of such on their own behalf. The parties going into contracts do so in order to establish a system of certainty and accountability as a result of a potential shared interest. And a contract is entered into only when an offer made by party A is considered by party B and then accepted. This is the moment at which a contract is accepted. A contract does not truly begin until it has been fully accepted by both parties. The challenge with these agreements is usually those of enforcement. If a court can't enforce it, then the contract is useless. And the courts, of course, play a big role in the interpretation of the terms in these contracts in these situations, whether that be writing words or other source of documentation of the agreements in the contract. That would be all.
Well, yeah, that's all we have for you today. Thank you for listening. Bye.